Welcome to our 2019 NILG Conference webcast. Thomas Houston had the pleasure of attending this year's National Industry Liaison Group Conference from July 30th through August 2nd. As a consultancy that specializes in affirmative action and equal employment opportunity, this webcast contains those sessions attended by our team that were directly related to our main line of business, affirmative action compliance. As such, as we move through this presentation, you will notice that the focus on many of the attended sessions were compliance evaluations, including focused reviews, individuals with disabilities, Section 503, VEVRA, veterans, and equal employment opportunity. We will begin by reviewing and highlighting the various sessions that our team was able to attend during the conference, and then provide a brief summary of other sessions that ran simultaneously. We will explain how the OFCCP and the NILG are collaborating to assist the federal contracting community. We will then review the opening remarks as presented by OFCCP Director Craig Lean, information on the corporate scheduling announcement list released in March of 2019, focused reviews, Section 503 and VEVRA, the OFCCP's Pinnacles of Change, early resolution procedures, EEOC Commissioner Victoria Lipnick's Day 2 opening remarks, and finally a summary of other sessions on the 2019 NILG conference schedule. The OFCCP and the NILG have collaborated to assist the federal contracting community, as mentioned earlier. The OFCCP enforces laws that prohibit federal contractors and subcontractors from discriminating against protected classes. The NILG is a nonprofit employer association focused on affirmative action and equal employment opportunity. They had entered into a Memorandum of Understanding in September of 2018 to support federal contractor education and training, enable proactive compliance with OFCCP regulations, and minimize the cost of compliance by contractors. At that time, Acting Director Lean said that this memorandum assists in further engagement and dialogue with the contractor community and leads to greater transparency, more effective compliance assistance, and comprehensive compliance by contractors with equal employment opportunity and anti-discrimination obligations. During the conference, transparency was a key ingredient in many presentations and emphasized in Director Lean's opening remarks. Director Lean opened the conference and asked everyone to remember one thing, that it is time in this country to treat individuals with disabilities the same. He received applause and a lot of nodding heads after that statement. His focus for most of the presentation was on individuals with disabilities. He referenced the low hiring rates and the wide pay gap of these individuals. He mentioned that on average, the cost of an accommodation was $500 or less. He was also very passionate that the disabled community was an untapped resource. This led his discussion regarding the need for focused reviews to make a positive impact for individuals with disabilities. During his remarks, he talked about the new courtesy scheduling announcement list of 3,500 establishments for fiscal year 2019. It included establishment-based compliance reviews, corporate management compliance evaluations, or CMCEs, functional AAP reviews, Section 503 focused reviews, and compliance checks. To further explain this courtesy list, it provides contractors a 45-day courtesy notification prior to when the OFCCP begins sending its Office of Management and Budget, or OMB-approved scheduling letter. After receiving the scheduling letter, contractors will have the standard 30 days to submit their affirmative action plans, or AAPs. As a result, all contractors on the current list are receiving a minimum of 75 days advance notice to have the AAPs ready for submission. The OFCCP will also grant a one-time 30-day extension for supporting data where AAPs are provided timely, as indicated in the OFCCP's FAQ on requesting an extension for submission of AAPs and supporting data. This data collection is approved by the OMB under the Paperwork Reduction Act. The OFCCP limited the scheduling list to no more than 15 establishments of any parent company. No establishment that received a scheduling letter, concluded a review, or concluded progress report monitoring resulting from a conciliation agreement or consent decree within the last 2 years is included on the scheduling list. Desk audits are considered a major part of a compliance review. Every compliance evaluation must include a desk audit, no matter what other methods of investigation are used as well. The contractor will receive a scheduling letter requesting information. The contractor should review its government contracts to ensure that it is indeed covered, and it should advise the OFCCP if it does not believe it is a covered business. The contractor should share with the OFCCP if none of their facilities or corporate entities has any government contracts or the contractor does not otherwise meet the threshold requirements for developing an affirmative action plan or AAP. The OFCCP has the burden of proving coverage, and the contractor is not obligated to provide any information until coverage is established. Before submitting any documents, the company should conduct its own internal desk audit to verify that it is in compliance with the laws and regulations. The contractor has 30 days to provide the requested information. The OFCCP will review the contractor's AAP and supporting documents away from the work site to determine whether the contractor is in compliance. We will now begin the review of the different types of compliance evaluations scheduled and performed by the OFCCP. An establishment-based compliance review consists of a scheduling letter addressed to the specific location under review. The evaluation is used to determine if the contractor maintains non-discriminatory hiring and employment practices and is taking affirmative action to ensure full compliance with the requirements of Executive Order 11246, VEVRA as amended, and Section 503 as amended. This audit is conducted to ensure that the contractor makes employment decisions without regard to race, color, religion, sex, and national origin, unless additional good faith affirmative action efforts are conducted. To conduct a functional AAP evaluation, the OFCCP National Office FAAP unit schedules evaluations and coordinates with the regional office and district field offices. It assesses whether the FAAP agreement is current, the business or functional unit is reflected in the FAAP agreement, and depending on identified desk audit issues, a possible on-site at multiple locations could be scheduled. At the conclusion, the field office closes the review and notifies the national office of its results. A more focused evaluation process is the Corporate Management Compliance Evaluation, or CMCE, which focuses on mid-level and senior corporate managers. Contractors must avoid discrimination and make good faith affirmative efforts to guarantee equal employment opportunity in developing, selecting, and treating mid-level and senior corporate managers. The CMCE is designed to make sure qualified minorities, women, persons with disabilities, and protected veterans do not face artificial barriers to advance into and within mid-level and senior corporate management. A focused review is an on-site review of one or more components of the contractor's organization or one or more aspects of the contractor's employment practices. Compliance officers use the focused review to target selected employment issues of an institution or employer. Besides the Section 503 Focused Review, as previously mentioned, you will notice we have added the VEVRA Focused Review to our list as we discuss this type of review. We will have more information later in this webcast. A compliance check determines whether a contractor maintains records consistent with their obligations. The contractor will receive a scheduling letter requesting the documents, and once the review is considered complete, the contractor will receive a closure letter. Let's focus on the Section 503 focused reviews at this time. Director Lean said that the OFCCP has committed to performing all 500 focused reviews as listed on the current courtesy scheduling announcement list. The OFCCP maintains an outreach directory and has prepared a what to expect guide for federal contractors undergoing a focused review. They will also be releasing a WebEx training, and scheduled contractors will receive an on-site plan from the OFCCP. Section 503 Focused Reviews will include a comprehensive review of the contractor's policies and procedures as they relate solely to Section 503. These focus reviews will be scheduled at the employer's headquarters location. The reviews will include an on-site investigation and interviews with managers responsible for equal employment opportunity and Section 503 compliance, such as the ADA coordinator, as well as employees affected by those policies. The OFCCP would also seek to evaluate the handling of accommodation requests to ensure that individuals with disabilities are not being discriminated against in employment. So the question is, with the reduced number of OFCCP staff in the last few years, is the OFCCP ready to perform these focus reviews? The OFCCP addressed this question during the conference and said that 2 groups have already been trained on how to perform these reviews. There are a few groups still in training, but those that are trained make up 75% of the focused review team. The OFCCP staff has been directed to work towards ensuring that a portion of future scheduling lists starting in fiscal year 2019 include focus reviews. These reviews will be selected from the same neutral system used to identify and create the OFCCP supply and service scheduling list. The staff is directed to develop a standard protocol for conducting the focused reviews and to make this information available publicly in its FAQs prior to the next scheduling list's release. The OFCCP staff has also been directed to develop staff training and contractor education and compliance assistance to provide guidance as to the focused reviews. You can learn more about focused reviews by reviewing Directive 2018-04 on the OFCCP website link shown below, which established focus reviews under Executive Order 11246, Section 503, and VEVRA. As the focus reviews will be scheduled at corporate headquarters, they will also consist of an on-site visit by the OFCCP. The off-site resolution will follow the on-site visit, and the OFCCP estimates that visit to last from 2 to 5 days as needed. Managers as well as employees will be interviewed. Contractors will be informed of the information to be covered during the focused review via the focused review on-site letter that they will receive from the OFCCP. There are a few items that are necessary to cover regarding the focused reviews. There is currently a proposal at the OMB addressing a change to the Section 503 original scheduling letter. The original scheduling letter will be sent in the meantime, and as a result, there may be 2 letters out there at once. Once the new letter is approved by the OMB, it will replace the first letter, and any changes to the letter will be applied during the already scheduled focused reviews, regardless of what stage of the audit that your organization may be in at the time. This will be handled by the CO as necessary at the time of the audit. The closure letters for focused reviews will be the same as desk audit and other reviews. The OFCCP has a sample AAP on their website. The OFCCP has key focus areas among others, so we will highlight a few for you in this webcast. The OFCCP will review the accessibility and accommodation policies of the contractor. Throughout their review, they want to ensure that individuals with disabilities have equal employment opportunities. A contractor's harassment policies must cover disability-based harassment, and contractors must also provide reasonable accommodations. Some further focus areas include other contractor responsibilities, such as maintaining a centralized reasonable accommodation system, ensuring top leadership support, coordinating with state and local rehabilitation agencies, accessing available recruiting tools, offering flexible work policies, and researching and creating outreach programs. Contractors must also perform periodic reviews of their personnel policies and processes, such as their self-identification process as related to hiring, promotions, and training opportunities. They must develop processes to perform these periodic reviews and define what a periodic review entails. Once they perform the review according to its definition, the contractor should document the date of the process review and document what actions were taken. These, among other key focus areas, can also be found on the OFCCP website. What does the OFCCP and the EEOC do with individuals with disabilities information? The OFCCP utilizes the information in neutral selection for audits, including individual complaints, to schedule focused reviews and on-site visits to contractor headquarters and review their company-wide policies. The EEOC investigates individual complaints, enforces commissioner charges, and develops strategic enforcement plans. A brief summary of Section 503 affirmative action obligations includes a contractor utilizing the voluntary self-identification process, hire and applicant reporting for individuals with disabilities, analyzing individuals with disabilities utilization, conducting outreach even if the goal is met, and maintaining an annual written outreach evaluation. As a side note, although the Americans with Disabilities Act, or ADA, is a civil rights law that prohibits discrimination against individuals with disabilities in all areas of public life, it does not require recruitment of individuals with disabilities, unlike Section 503. An employer's annual review of their personnel processes under Section 503 obligations would include, but is not limited to, a review of the application process, the selection and employment process, and the annual AAP processes. The application process should include internal and external perspectives, access to online application processes, and the self-identification process. The selection and employment process should include the review of access to systems used during employment, the review of hire, promotion, and termination processes, reasonable accommodations for interview processes and training materials. It should also include a review of the EEO and harassment policies, and that they should include disability protections. The annual AAP process should include documentations of dates when reviewing the affirmative action plan and setting a goal for the organization to do more utilizing of their AAP statistics, to name a few. We will now review a few steps that employers should take or focus on regarding reasonable accommodations. They should have interactive dialogue with their employees to determine the essential functions of the job that can be performed. establish that individual's limitations, ensure potential accommodations, select the most appropriate accommodation, monitor the effectiveness of the accommodation, and provide a report of all accommodation requests and denials. The key focus for an employer should be, once again, to review their EEO and harassment policies to include individuals with disabilities, pregnancy-related requests, their documentation process, and to provide training to managers on common compliance concerns. The EEOC mentioned that they received 11,000 charges in 2018 alleging failure of an employer to accommodate their employees. Let's review a few resources to assist with your organization's disability efforts regarding policies, inclusion, and workplace accommodations for individuals with disabilities. ODEP, or the Office of Disability Employment Policy, is a part of the Department of Labor. It is non-regulatory and promotes policies and coordinates with employers and all levels of government to increase workplace success for people with disabilities. Their mission is to develop and influence policies that increase the number and quality of employment for people with disabilities. The Employer Assistance and Resource Network on Disability Inclusion, or EARN, serves as a centralized source of employer-focused tools, resources, and publications on disability inclusion. Their website includes easy-to-navigate information on a wide range of topics, from recruiting qualified job candidates to tax incentives for hiring people with disabilities. The Job Accommodation Network, or JAN, is the leading source of free, expert, and confidential guidance on workplace accommodations and disability employment issues. Now, to change direction a little, Director Lean shared with everyone at the conference that the OFCCP was currently developing plans for VEVRA-focused reviews. He stated at the conference that the OFCCP is hoping to publish a list of veterans-specific focus reviews around Veterans Day, November 11, 2019. They have been working on implementing a comprehensive initiative that seeks to ensure compliance with equal employment opportunity and anti-discrimination regulations. A directive released in August of 2018 stated that a portion of the future scheduling lists include focused reviews as to each of the three authorities: Executive Order 11246, Section 503, and VEVRA. An update to this conference information is that on August 7th, Director Lean shared with those attending a town hall session in Washington, D.C., that 500 scheduling letters would be going out on Veterans Day for VEVRA-focused reviews. He also discussed that the agency would put an emphasis on the underemployment or non-employment of veterans with disabilities, as well as military spouses. As we get closer to the release of the scheduling letters for VEVRA-focused reviews, we will be updating our website regularly to include any materials, guidance, explanations, etc. that the OFCCP releases regarding these new focused reviews. We encourage all contractors to begin to review their policies and procedures regarding veterans. Now that we have covered the Section 503 obligations and requirements for focused reviews and the announcement of VEVRA focused reviews, we will now return to the discussions on Section 503. On September 24, 2013, the OFCCP published a final rule in the Federal Register revising the regulations implementing Section 503 of the Rehabilitation Act of 1973 as amended. The regulations became effective on March 24, 2014. This 5-year anniversary reminds contractors to review their progress on attracting, selecting, advancing, and retaining individuals with disabilities in the workplace, highlight effective outreach initiatives and programs, as well as prepare for the 5-year invitation for employees to voluntarily self-identify their status as an individual with a disability. This 5-year interval requirement is specified under Subpart C of the regulation and should be included as an action item for contractors to discuss and plan for in the upcoming year. To clarify, the employer must invite their employees to self-identify every 5 years, beginning the first year that they became subject to the Section 503 voluntary self-identification requirements. So it may be time for many contractors and subcontractors to begin conducting their resurvey if they have not already done so. To further explain when the requirements began, employers with completed AAP plan dates between April 1st of 2014 and December 1st of 2014 should have fully implemented the assessment and reporting requirements beginning with their 2015 AAP. Those employers whose upcoming plan dates were between January 1st of 2015 and March 1st of 2015, when the requirement became effective, were required to implement the assessment requirements with their 2015 AAP, although their reporting requirement began with their 2016 AAP. Therefore, the 5-year invitation requirement is fast approaching for all employers. Although contractors are to resurvey their workforce at least once every 5 years, they are to also issue at least one reminder between invitations. There is also a requirement that contractors regularly invite all of their employees to voluntarily self-identify as an individual with a disability and remind employees that they may voluntarily update their disability status at any time. Director Lean expressed the OFCCP's ongoing commitment to assist federal contractors with their Section 503 responsibilities and strengthening the partnership between the OFCCP and federal contractors. Shortly after this conference, on Friday, August 8, 2019, the OFCCP announced a new landing page dedicated to Section 503. The following slides will walk you through the various sections on the landing page. Contractors can find several links to useful information, including sections on 503 focused reviews, a disability inclusion video explaining why federal contractors ask job applicants and employees to voluntarily self-identify, a disability rights fact sheet explaining job seeker and employee rights, and best practices to assist federal contractors with compliance. We have included the link to the Section 503 landing page on each of the informational slides. As mentioned in the previous slide, the landing page is to assist federal contractors with Section 503 regulations. It will also include the Section 503 regulations as an easy resource, resources to provide assistance, guidance, support, and advice, a requesting a reasonable accommodation pocket card to assist applicants, employees, and other interested parties in understanding the process to request a reasonable accommodation, and the OMB approved voluntary self-identification of disability form CC 305. The landing page also includes a sample Section 503 AAP, the Office of Disability Employment Policy, or ODEP resources, a section on how to file a complaint in the case of discrimination in hiring or employment, and the OFCCP's office directory to find the person you need and/or their toll-free helpline. We are now going to shift a little and concentrate on the OFCCP. When Craig Lean was acting OFCCP director, he was a key speaker at the 2018 NILG conference held in Anaheim, California. He spoke to the group about the 4 pinnacles of change the current administration is focused on, which are transparency, certainty, efficiency, and recognition. The now OFCCP Director Lean reinforced those 4 pinnacles of change at the 2019 conference. He stated that the OFCCP is working to ensure transparency in all stages of a compliance evaluation, provide contractors with resources and documents, adding a certainty that they are complying with their obligations, conducting high-quality, consistent, and efficient compliance evaluations, ensuring that there is open communication, cooperation, and an intent to minimize unnecessary burden and to make considerable efforts to resolve violations through conciliation. The OFCCP also released Directive 2018-06 in August of 2018 to recognize contractors with high quality and high performing compliance programs and initiatives. While we are reviewing the 4 pinnacles of change that the current administration is focused on, it is a good time to review what contractors' obligations are while working with the OFCCP. These obligations include ensuring non-discrimination and affirmative action in the workplace through the implementation of Executive Order 11246, Section 503, and VEVRA requirements, submitting their affirmative action plans and support data on a timely basis when scheduled for a compliance evaluation, and allowing the OFCCP access to its records and establishments in accordance with applicable laws and contractual provisions. Director Lean concentrated on the first pinnacle, transparency, and it echoed throughout the conference. Directive 2018-08 was released on September 19th of 2018 and is intended to ensure transparency in all stages of OFCCP compliance activities, to assist contractors to comply with their obligations, know what to expect during a compliance evaluation, and to protect workers from discrimination through the consistent enforcement of OFCCP legal authorities. The compliance evaluation procedures described in this directive supersede any procedures in the Federal Contractor Compliance Manual, or FCCM, or other previously issued guidance to the extent they could be read to conflict. For further information on this directive, use the link shown below. As part of the OFCCP's effort to implement this guiding principle, the OFCCP staff must follow certain procedures, such as delaying the scheduling of an audit until 45 days after the corporate scheduling announcement lists are published, providing contractors more time to prepare for the evaluation and participate in a regionally sponsored compliance assistance event. Publishing the OFCCP's supply and service scheduling methodology on the Internet to be more transparent about how the OFCCP neutrally selects federal contractor establishments for a compliance evaluation. Contacting the contractor within 15 days of sending the scheduling letter. Providing maximum time for contractors to receive the technical assistance they need to comply with the scheduling letter and itemized listing. Providing a 30-day extension for contractors to provide supporting data as related to Executive Order 11246, VEVRA, and Section 503 AAPs. A contractor's failure to submit their AAPs and/or supporting data in a timely manner, including those with approved extensions, will result in immediate issuance of a show cause notice on why the OFCCP should not initiate enforcement proceedings. During this period, the contractor will have an additional 30 days to provide the AAPs and supporting data in response to the show cause notice. A procedural notice to show cause for failure to submit AAPs and/or supporting data does not require OFCCP National Office approval. Upon receiving the AAP and supporting data, the OFCCP should contact the contractor or their representative immediately to confirm receipt. They should begin the desk audit promptly, ideally within 5 days after receiving the AAP. Next, they should review the AAPs and supporting data submission to make sure they are complete and acceptable, and notify the contractor promptly of any incomplete or unacceptable desk audit submissions, and allow 15 days to provide complete and acceptable submissions. Begin the analysis of supporting data only after the AAP and supporting data are complete and acceptable to minimize time and duplication of work. Contact the contractor to request follow-up information at the desk audit phase only to fulfill and, if necessary, clarify the data requests required by the scheduling letter and itemized listing. The OFCCP should work to close reviews quickly where there are no indicators of discrimination or evidence of other violations. Ideally, and in the majority of cases, the OFCCP would complete a typical desk audit within 45 days of receiving complete and acceptable AAPs and supporting data. By applying the above principles nationwide, the OFCCP should significantly improve its ability to meet this goal. The OFCCP has obligations to the contractor when preparing for a potential on-site visit. They should prepare supplemental requests for data and information beyond the items provided in response to the scheduling letter and itemized listing to refine indicators. They should ensure that information requests include the basis for the request, be reasonably tailored to the areas of concern, and allow for a reasonable time to respond. Tailoring the scope of a supplemental data request does not limit in any way the OFCCP's authority to confirm compliance with other requirements or investigate other potential violations that it discovers during the course of the compliance evaluation. They should include a high-level summary of any preliminary indicators of discrimination in the on-site confirmation letter. The off-site analysis should begin immediately once the on-site is complete. They should maintain regular contact with the contractor or their representative, ideally at least once every 30 days, to keep them informed about the status of the evaluation. The OFCCP's conciliation efforts take a collaborative approach with contractors during the exchange of information to promote a shared understanding of the issues and to promote resolution. This includes sharing information and essential source data in electronic format to assist the contractor in understanding and replicating the OFCCP's findings, sharing factors used to calculate back pay, and by providing an overview or summary of anecdotal evidence or non-statistical findings to add context to the statistical results. They should also include the branch of expert services or the office of the solicitor staff, where applicable, to support conciliation efforts. As we have briefly reviewed the OFCCP's Pinnacles 2 and 3, Certainty and Efficiency, in the Compliance Evaluation and Transparency sections, we will move to the fourth pinnacle, Recognition. The OFCCP has established a recognition program to recognize contractors with high-quality and high-performing compliance programs and initiatives. These programs should have a record of accomplishment related to non-discrimination and providing applicants and employees with equal employment opportunity under the laws enforced by the OFCCP. The OFCCP's intent is to highlight specific contractor programs and initiatives that are innovative, have achieved demonstrable results, and that could be taught or incorporated into contractor peer mentoring programs. Director Lean also included the Early Resolution Procedures Directive 2019-02, released on November 30th of 2018, in his remarks over the course of the conference. This directive appears to have been designed to address a long-standing frustration of the OFCCP regarding the structure of the compliance audit process, that it is generally limited to a single establishment or functional unit. This directive rescinded the Obama administration's Active Case Enforcement Directive. The OFCCP believes that this program can reduce the length of a review and therefore reducing the audit burden for contractors, providing faster resolution for class members, and resulting in fewer aged cases for the OFCCP. Through its compliance audits, the OFCCP reviews a single establishment or functional unit of a contractor, focusing on its technical compliance, progress toward goals, and hiring, promotion, termination, and compensation data. When the OFCCP identified a technical violation or a discriminatory practice, it did not have a mechanism for addressing similar violations at other establishments or functional units of the contractor. The directive offers advantages for the contractor beyond the potential 5-year moratorium on audits. Contractors can take advantage of this program to try to resolve potential violations early in the audit process. In addition to conserving resources, the contractor avoids the disruption of on-site inspections, employee interviews, and responding to extensive document and data requests. The Early Resolution Procedures Directive is applicable to all current OFCCP compliance audits in which a predetermination notice, notice of violation, or show cause notice has not been issued as of November 30th, 2018. The Early Resolution Procedures Directive offers the OFCCP and contractors a mechanism for undertaking a mini-audit focused on specific technical violations or findings of discrimination uncovered during the desk audit phase. After the desk audit was performed for technical violations or an on-site for potential findings of discrimination, the OFCCP would propose an early resolution conciliation agreement that resolved the violation at both the establishment under audit and at other establishments of the contractor covered by this conciliation agreement. The OFCCP would not issue a notice of violation if the OFCCP and the contractor entered into this agreement. With an early resolution conciliation agreement, the OFCCP would agree not to subject the contractor to an audit for 5 years at either the original establishment if the agreement involved technical violations, or all establishments covered in the agreement if the agreement resolved discrimination allegations. However, during this period, the contractor would be required to provide periodic reports to the OFCCP consistent with the terms of the agreement. Also, the OFCCP would have the right to investigate individual claims of discrimination and suspected violations of the conciliation agreement. The OFCCP would reserve the right to initiate an enforcement action and void the early resolution conciliation agreement if a contractor violated it. The 5-year moratorium on audits would not relieve the contractor of its ongoing obligation to comply with OFCCP affirmative action and non-discrimination obligations. You will be able to find further information on the following by accessing the OFCCP's link below. It includes information on the OFCCP's roles and responsibilities, what is required where there are non-material and material violations, the advantages and disadvantages of an early resolution conciliation agreement, the process the OFCCP utilizes, examples of what may be requested and expected, and steps of the process from information gathering, periodic reporting, and conciliation efforts. EEOC Commissioner Victoria Lipnick made the opening remarks on Day 2 of the conference. Commissioner Lipnick first became a commissioner for the EEOC in 2010, and in 2015 the Senate confirmed her for a second term, which will end in July of 2020. Commissioner Lipnick last addressed the ILG National Conference in 2016, talking about pay data reporting. Sounds familiar, doesn't it? She shared with the 2019 audience that the goal is to have everyone comply by the end of September 2019 to satisfy Judge Chutkan's order. She also mentioned that collection of pay data is not easy, and furthermore, going back to 2017 is not in any way easy, but that is what a federal judge has ordered. Commissioner Lipnick didn't feel that this was the way for public policy to be made. She offered a bit of advice of a lesson learned by the agency. If you want your interests to be heard, you must intervene. She said the agency is going to take a breath and learn from what they receive in respect to the data to make an honest assessment. She would like a bipartisan and open process to learn about the use and burden associated with the report, and encouraged attendees to track the burden associated with filing the pay data reports. In her view, balancing burden and utility is what good policy should be all about. Commissioner Lipnick then turned to another of her favorite topics, age discrimination. She pointed out that millennials are just a few years away from being covered by the Age Discrimination Act. She also touched briefly on the fact of the 5-year anniversary of the ADA Amendments Act, which increased protections for individuals with disabilities. One of Commissioner Lipnick's current priorities includes launching the Employer Opportunities Project, designed to assist older adults trained for a new job, and exploring ways to prevent companies from retaliating against employees who file age-biased complaints. In Commissioner Lipnick's words, there is so much talent in older workers, we as a country, for all of our economic purposes, should not leave that on the sidelines. People are living longer, and if you are going to live longer, you're going to have to work longer. Commissioner Lipnick answered a simple question from an attendee. As federal contractors, what do you want us to focus on? Her response was equally as simple and thought-provoking. She encouraged contractors to lead the way in recruiting for populations you traditionally have not gone to before. Another conference session introduced the EEOC's Chief Data Officer, Chris Haffer, who leads the Office of Enterprise Data and Analytics, or OEDA. In May of 2018, this office was created to provide their customers timely, accurate, and bias-free data and information to prevent and remedy unlawful employment discrimination and improve organizational performance. The launch of the OEDA should prompt employers to reconsider waiting to leverage data and analytics in managing their workplace. Using data and analytics in the workplace is not a passing fad. A further goal of this office was to develop an enterprise-wide data analytics system, utilizing state-of-the-art data and information science tools to enhance mission effectiveness and make the EEOC's data readily available to both internal and external users. It was clear to me the agency had to make some dramatic change to bring our capacity into the 21st century, said the then EEOC Acting Chair, Victoria Lipnick. At this conference, she stated, we also had to address important issues about data protection, access, and internal data governance. The new OEDA allowed us to do all of that. Equally important, Lipnick added, the EEOC sits on a treasure trove of data. We will now be able to make better use of that data with consistency to better serve our customers and the mission of the agency in a more efficient and effective manner. There were many conversations among attendees about the W-2 pay data reporting due by September 30th of 2019. Contractors must file the W-2 pay and hours work data for 2017 and 2018 by this deadline date. Dr. Haffer said there would be no automatic extensions. He also mentioned that data cleanup would likely take until at least January of 2020, after which the files would go to the EEOC for analysis of data quality and utility. With more than 50 sessions offered at the conference, it is virtually impossible to attend each one. In case you were wondering what type of information is available to employers, federal contractors, attorneys, consultants, and vendors that attend this conference, we have added the subject matter that was covered in various presentations. There were several sessions on affirmative action, from learning the fundamentals of an AAP, the history and laws as related to affirmative action, compliance evaluations, data collection, cleaning up your data, data analytics, impact ratio analysis, dispositions for applicants, census matching, Section 503 and VEVRA, functional affirmative action plans, and more. You can also learn about how the ADA, FMLA, and workers' compensation intersect in the world of human resources and discrimination. Civility in the workplace is an important part of maintaining a culture of respect and civil behavior. Compensation is another component that attracts many conference goers, where discussions included utilizing regression analysis versus descriptive statistics, determining competitive pay levels for a specific job or jobs within an organization, elements of a compensation pay philosophy or strategy, salary surveys, leveraging your OFCCP compliance efforts in regards to pay equity, and more. Employment discrimination and inclusion and diversity sessions were held, which touched on topics such as expanding your talent pool, successful workplace disability inclusion programs, diversity in language and communications, diversity and inclusion as related to compliance, and more. Identifying risk in the world of artificial intelligence and big data. What do organizations do with this information? Some use them to source candidates, evaluate talent, predict a cultural fit. They use it in their succession planning. Immigration and ICE enforcement. What is included in your compliance program? It is every employer's responsibility to ensure internal compliance. OFCCP and higher education, including audit case studies. Recruitment, selection, and retention programs, including social media in the world of talent acquisition and internet applicants, and more. As much as we have enjoyed attending this year's NILG conference and sharing the highlights with you, we hope you will be able to utilize this information in your ongoing affirmative action compliance efforts. The information provided in this webcast has been gathered from the various presentations at the 2019 NILG conference held in Milwaukee, Wisconsin, and from the OFCCP, EEOC, and Department of Labor websites. You can follow Thomas Houston on our social media sites listed below. To receive further information on any of the information included in this webcast or regarding our affirmative action services, you can contact our Sales and Marketing Department by calling 1-800-330-9000 extension 110, or send a request via email to info@thomashouston.com. Thank you for your time and interest in today's webcast.